Welcome everyone to our event today, Legal Perspective on Executive Orders Impacting DEI Efforts. If this is your first time joining us, I'm your Managing Director at Bonn Search Partners, a modern executive search firm specializing in placing thought leaders across diverse industries. Our team has over 20 years of retained search experience. We help startups, scale-ups, and hypergrowth companies build high-performing executive and board teams. I'm so thrilled to have Ken with us today to dive really into this important discussion. Let me introduce you all to our speaker, Ken Rosenberg. Ken is a highly respected labor and employment attorney with extensive experience advising employers on complex workplace compliance matters. As the head of Fox Rothschild's Affirmative Action, OFCCP practice, he provides practical and strategic solutions to businesses navigating federal, state, and municipal labor regulations. With a deep understanding of prevailing wage laws, such as Davis-Bacon Act, Service Contract Act, and Walsh-Healy Public Contracts Act, Ken partners with business owners, HR professionals, and in-house counsel to ensure compliance with evolving labor laws. Ken also assists his clients in developing and implementing employee handbooks, personnel policies and procedures, and employment and severance agreements. He also provides day-to-day counseling and training to his clients in connection with all federal, state, and local laws that impact the employment relationship, including but not limited to disciplinary, leave and accommodation, wage, and hour issues. A recognized thought leader, Ken is frequently invited to speak at industry conferences and legal education programs on employment law and affirmative action plans. Ken, thank you so much for being with us today and everyone in the audience for tuning in.
Marie, it's a real pleasure to be able to present to your group today.
Thank you. Just a few house rules before we get started. Please feel free to keep your camera on if you're comfortable. We would love to see you, but please do keep in mind your mic muted to avoid any interruptions during our discussions. Our aim for these events is for everyone to walk out with more than they came in with. So feel free to network in the chat during the event and drop your LinkedIn profile. That being said, we'll also have some Q&A portion at the end of our discussion. So put any questions or comments that you would like us to address in the chat, and we'll make sure to get to them. So let's go ahead and jump right in, Ken. Ken, since President Trump issued executive orders aimed at rolling back DEI initiatives within federal government, as well as effects of DEI programs in the private sector, I've been getting actually a flood of calls from both candidates and clients. Everyone from candidates asking me, how does this affect my current role? Will it impact my future career prospects? To clients asking me, what are the immediate compliance or legal risk we need to watch out for? These are big questions, and we're really all trying to figure out how to adapt to this fast changing executive orders that's been in place. So please help us understand and just walk us through key executive orders impacting these efforts and what do they specifically prohibit or change?
Sure. So just to give a little historical context to the new executive orders that were recently issued, in 1965, President Johnson issued Executive Order 11246. That executive order required federal contractors and subcontractors to prepare annual affirmative action plans. And those affirmative action plans essentially was a statistical analysis of a federal contractor's workforce. So it involved performing an underutilization study to determine whether the contractor had underutilization of employees based on race, ethnicity, or gender. And that executive order applied to specific types of federal contractors. It didn't apply to everyone, but you had to have at least $50,000 in contracts and 50 employees. And then there were some entities like banks and financial institutions. I heard we have someone on the line listening today who is at one of those organizations. They had to or were subject to this executive order. That really set the groundwork for all DEI and affirmative action programs that were mandated by federal, state, and local entities thereafter. So we're talking about an executive order that was in existence for about 60 years. Wow. And fast forward, more recent administrations have implemented, promulgated other executive orders to protect other groups based on, for example, sexual orientation or gender identity, and expanded those programs to include more and more individuals in protected classes. Two laws that were actually passed in contrast to an executive order, which is just a executive administrative action. In contrast, Congress enacted two laws. One is the Vietnam era Veteran Readjustment Assistance Act of 1974 that protected veterans, and then Section 503 of the Rehabilitation Act of 1973, which protected individuals with disabilities. And those two statutes essentially protected those protected classes and also required federal contractors and subcontractors to prepare affirmative action plans for those two protected groups. Again, there were additional executive orders and guidance issued by the federal government to implement those statutes and regulations. Fast forward now, like I said, to the new executive orders that President Trump issued recently, and we're just going to really have time today to only really talk about two of the major ones, which was Executive Order 14151 and Executive Order 14173. Those two executive orders, 14151, essentially is the executive order that is entitled Ending Radical and Wasteful Government DEI Programs and Preferencing. That executive order is really geared towards instructing the federal government and all of its agencies to end diversity, equity, and inclusion programs within the federal government, and to also instructed those federal agencies to essentially cancel any contracts or grants that the government had entered into previously, which were DEI related. And then the second executive order, 14173, also, which is entitled Ending Illegal Discrimination and Restoring Merit-Based Opportunity, also has the intent and impact to discontinue diversity, equity, inclusion programs within the federal government, and to try and attempt to encourage federal contractors and subcontractors to essentially stop their affirmative action plans, and to encourage private entities, corporations, not-for-profits, higher educational institutions from engaging in diversity, equity, inclusion. The difference between affirmative action and diversity and equity inclusion should be noted, because affirmative action, again, is built on the Executive Order 11246 and requires federal contractors and subcontractors actually to do a statistical analysis of their workforce and determine whether there's underutilization, and then to engage in outreach and recruitment to correct that underutilization over the period of time without using preferences or illegal quotas. The affirmative action plans also require those contractors to prepare annually impact ratio analyses, which is an adverse impact study examining the contractor's employment activities, specifically hiring, firing, and promotional activity. And if it's basically a disparate impact analysis to determine whether that employer is engaging in disparate or engaging in policies that have a disparate impact on a protected class. Those affirmative action plans also required covered entities to perform a compensation analysis, pay equity analysis, to determine whether any of the pay compensation schemes have an adverse impact on a protected group. Diversity, equity, and inclusion, in contrast, doesn't require necessarily any of those analyses, but the policies and programs are intended to do is to broaden a business's activities and workforce activities to touch and reach all groups that may be either protected minorities or females, or a group that is marginalized in society. And so it's not specifically required necessarily by a law, but it was policies and programs that were encouraged by the federal government through various mechanisms, whether it's federal contracts or grants, executive orders, And it trickled down through the economy from those entities that were doing business directly with the government to other entities that realized that diversity, equity, inclusion really is beneficial to their business. And to get a diverse workforce, it was important to make everyone feel welcome within the workplace and to also try and correct deficiencies that had existed for marginalized groups. So those are the two main executive orders we're talking about here today, 14151 and 14173.
Yeah. Thank you for that breakdown in the history for this executive order, but want to focus a little bit more within the private sector because I do have a client, a mid-sized tech company I'm currently working with. They invested heavily on their DEI program early last year with a lot of mentorship initiative, diverse hiring panels, and a lot of those unconscious bias training. So now they're really worried that these new executive orders, they may be forced to scale back on these efforts, right? Their HR directors keeps asking, do we need to pump our brakes on DEI or can we keep pushing forward without risking legal trouble? But based on what you've shared, sounds like companies really need to be extra careful about how they frame their training and policies to avoid some of these legal headaches. Is that the case?
That's absolutely true. I have to note that both Executive Order 14151 and 14173 have both been challenged in court recently. And actually, a judge in the U.S. District Court of Maryland just on Friday issued an injunction for parts of the most problematic portions of those executive orders. So this story is still being written, but our advice to businesses about what they should do, because we get lots of calls now about businesses want to know what they should be doing to be compliant and not to become the focus of an investigation by the government or litigation, which is potential issues that were raised in these new executive orders. And we advise our clients, basically, first thing is to keep abreast of the changes that are occurring. First of all, understand what the law is, obtain guidance and advice when necessary, remain up to date on new legal challenges, because all these things are affecting the environment that we're working in. Our reading of the executive orders, even if they were upheld by the Supreme Court ultimately, is that employers should never, under any circumstances, be engaging in illegal quotas or preferences when it comes to any employment activity, whether it's hiring, firing, promotions, whatever. Everyone should be assessed based on their abilities and knowledge and experience as opposed to some protected class. And so what we're telling our clients is, look, if you have a diversity, equity, and inclusion program, you just have to review that program to make sure it wasn't creating or implementing an illegal quota or preference system. And to be totally transparent, there are businesses that had programs that were geared towards just targeting specific protected classes for hiring. And that's not legal. Even without these executive orders, that could be deemed reverse discrimination. But if the intent of the organization is to make people feel welcomed, or even if you determine, hey, look, we have underutilization of some protected groups within our workforce, well, you can still engage in proactive outreach and recruitment to encourage qualified applicants to apply for openings. Or if you are interested in increasing the number of females within an organization into supervisory and managerial positions, because there's a dearth of that and there's underutilization of that group, you can still have mentoring and educational and other training opportunities that boosts up their skills so that they can be eligible for the promotions, but they can't be directed only at that group. So it has to be open to everyone.
Okay. I couldn't agree more. In the news recently, Ken, big companies like Costco, Apple, Microsoft are holding on to their DEI initiatives and refusing to scale back, which is great to see. But there's a twist there. These corporations also have shareholders who get a vote on how these businesses are run, especially during proxy season when critical decisions go up for approval. And proxy season is right now. Today, we're seeing this in the news, anti-DEI investor proposals, which is essentially calls for reducing or even stopping DEI efforts altogether. Things like diversity, ERGs, and training programs. So if enough shareholders back these proposals, these companies could be forced to roll back or even eliminate it altogether. But in the meantime, for these organizations who are focused on these DEI initiative, what steps should they take to make sure that they are remaining compliant to their commitment to workplace diversity?
Sure. Again, I think it's important. And just to talk about the proxy issue, initially, I've actually been asked to review certain companies' proxy statements and board governance guidelines and things like that to make sure that they don't create illegal quotas or preferences, especially given the EEOs that have just been promulgated. But if companies want to continue to engage in diversity, equity, and inclusion, it's a lot about the packaging and the wording at this point. So there's nothing that, this may sound to proponents of DEI programs, they don't want to rename those programs, but to avoid the ire of federal agencies like the Attorney General's Office, Division of Civil Rights, or anti-DEI activists from suing, I think the simplest way to get around that is, first of all, make sure that the programs don't have any illegal quotas or preferences. If they don't, and all you're doing is you're promoting diversity within the workforce, that is certainly permissible. There's nothing illegal about that under these executive orders. And you can still engage in outreach and recruitment to, again, bring a qualified applicants into your pipeline. And that's just one example. So for examples of what you can do is you can still attend job fairs that might be tailored or attract individuals from protected classes that you're looking to bring in to diversify your workforce. You can attend and promote open positions at colleges that may have a population that is geared towards a specific group, such as historically Black colleges. For individuals with disabilities, there are lots of organizations that assist individuals with disabilities find employment. Protected veterans, the same issue exists. There are organizations and there's state workforce development programs in every state of the United States that helps protected veterans obtain employment. And protected veterans, to be quite honest, are often heavily from underrepresented groups. By trying to attract, recruit, and engage in outreach for protected veterans, you're going to hit potentially two birds with one stone. So there are many different things that you can do. Those are external activities. Internal activities that you can do. Again, you can obviously celebrate people's differences, their culture, their religions. So when we have Black History Month in February, that's something that should be continued to be promoted. We recently had the Chinese New Year. That's another activity that you can promote internally also. And these are some soft areas, but it all is celebrating diversity within the workforce. And then within the promotional aspects of things, obviously maintaining and initiating mentoring programs to help individuals provide training. There's many different types of programs that you can run, as long as they're not geared towards a specific group. Again, it has to be open to everyone. But you can always encourage individuals to apply and participate.
It was sad because you're absolutely right. It's all about celebrating these different culture. Absolutely. I was hesitant to post Happy New Year's, Chinese New Year's, because of all these new regulations. Am I going to get in trouble for celebrating these different cultures, Black History Month? And I've seen that even across internally within our team. It's, should we post this? Should we not? So, companies have to have these guardrails and straightforward guidelines, really step-by-step plan to stay also, like you mentioned, legally compliant while staying true to their diversity goals. So it's all about standardizing hiring practices. And I think consistent documentations will help, and working closely with their legal team internally and, as you've mentioned, externally, so they can reduce a lot of these legal risks we're facing without giving up on their inclusive culture.
Absolutely. And some other things that I think businesses should be doing, which can assist and promote diversity, is you're still allowed to perform both an underutilization analysis, if you so desire, as well as an impact ratio analysis on your employment activities. There's nothing in these executive orders that specifically prevent that. What you're prohibited from doing is establishing some illegal quota or preference. And I keep going back to that because I think that's really where the lightning rod is going to be. If And obviously, those are two things that you can do. And then also making sure that you still do your pay equity analyses, because if you want to attract and retain the best talent from whatever group it may be, it's important to ensure that you're not engaging in some pay discriminatory practices. And by doing that, you're going to be able to retain a diverse workforce, the best skilled and qualified people that you're looking to retain.
These are all excellent efforts that a lot of organizations need to be in the forefront of their mind, and it's effective and it's good for them
Absolutely.
over the long haul. So Ken, it's, as I mentioned earlier, it's a trickle down effect. And as I've mentioned, a lot of my clients have spent years building a reputation for attracting diverse talent, creating that inclusive culture. But now with the new regulations, a lot of the talent acquisition teams are worried. They don't want to lose what they've worked so hard to build. Also, internal employees, they're feeling the impact too, asking questions about, like you said, promotion, pay equality, whether their ERGs might be affected. So it's understandable when your entire culture is built on inclusivity, any sign of change can really feel unsettling. So what does this mean for hiring managers, recruiters? Should they modify their hiring strategies to avoid any of these legal challenges?
Sure. So I'm just going to actually do represent various search firms and staffing companies. And over the past, since I've been doing this 15, 20 years, there have been instances where these companies have come to me and said, what do I do when a client, a customer comes to me and says, I specifically want somebody from this specific protected class to apply, to be sent to my company for open positions. And that type of request was illegal 15, 20 years ago, as much as it is now. Again, that could result in a reverse discrimination claim or a discrimination claim by another protected group, saying the other protected group is favored. So it's important from your perspective, from a search firm's perspective and hiring manager's perspective, that you evaluate your policies and procedures regarding hiring and ensure that they don't have some kind of overt or passive discriminatory effect on a group. And it's important to ensure, in order to, again, attract the best talent, it's important to engage. You're going to have to do extra work. You're going to have to make the efforts to go out and touch and follow up with various groups that help protected classes find employment and opportunities. Equal employment opportunity is still legal. It's important to engage in it. And again, touching and reaching out to organizations, not-for-profits that help protected groups find employment, colleges, advertising in the right or places where readers or in social media is what we're really talking about these days, where eyeballs are that are going to attract qualified applicants for these open positions. There's nothing illegal about doing that. That is all permissible. The government can't tell a search firm, a staffing company, or an employer for that matter, where they can look for talent. So you still have all those channels to try and locate and obtain applicants who are qualified for a job that may fall within a protected class. The key is not to engage in reverse discrimination, which is really what a lot of these two DEIs are really about.
We've covered a lot, but there's still plenty to unpack. Could things get even more complicated? Companies are looking for guidance on whether they should brace for additional legal challenges and policy shifts with our current political climate. Do you think there could be more changes, or should private companies, private sector stay course and continue building this inclusive or continue their DEI efforts? In other words, do you anticipate any further legal challenges or revision to these executive orders in the near future?
Oh, absolutely. And as I mentioned before, the federal lawsuit that was just filed or decided on Friday in Baltimore has already been appealed by the U.S. government to the Fourth Circuit of Appeals, which is the appeal court for Baltimore. And the injunction that was issued is still in force, but it could be lifted. And we know that there are many other organizations and entities across the United States that are initiating litigation on these executive orders. And the other issue that employers have to deal with in this space is that they may have state contracts that require them to prepare affirmative action plans for a specific state. For example, Minnesota, California, New York, New Jersey, they all have requirements. If a business wants to do business with the state government, they may have to be required on a state level to prepare an affirmative action plan. And that is completely contrary to these executive orders. Now, there's a legal concept called federal preemption, where a federal law will take precedence over a state law. There could be challenges brought based on that topic. If an employer or a business, a contractor that's doing business with the state says, I can't comply with these state requirements because the federal government's EO preempts it, and then they lose the contract, that could result in litigation. So there are many avenues where there could be substantial litigation in the future. If I had a crystal ball, I'd be able to tell you exactly what it is, but we're all in a wait and hold.
Yeah, I mean, it sounds like these orders can shift as political landscape evolve as well. But after all, diversity culture is more than just following orders, right? It's all about making sure everyone is feel valued, heard, and empowered to really succeed. So would love the opportunity to have our Q&A. My last thoughts and question is, where can companies turn, private sector, for legal advice to ensure they are navigating through these changes correctly?
Sure. There are a number of resources that private employers or not-for-profits, higher educational institutions, whatever, can seek out advice. There are FAQs that have been published by the federal government as to these executive orders. So if they want to do some of their own research, they certainly can do that. But speaking to an experienced employment attorney who has experience with AEP and diversity, equity, and inclusion, very good idea, because they're going to be the most well-tuned and understand the issues and how to avoid liability and ensuring compliance. Also, if you don't want to go the attorney route, you can always go to the Society of Human Resources Association. They're a great source of information. There are other organizations like the National Industrial Liaison Group, which is the NILG, which was formed after and to assist contractors comply with their affirmative action requirements. There are chapters all over the country. There are many different resources that employers can seek information in order to be compliant. And I'd encourage them to do that.
Great. That's a great list, both internally and externally. And obviously, for everyone in the audience, please feel free to reach out and connect with Ken. I'd love to get some Q&A now. Does anybody have any specific questions right now?
I have a question.
Yes.
What is the single biggest, or at least most frequent, concern that you're hearing initially? There's so many changes taking place and no one really knows where to turn. So much has changed in just such a short amount of time that there's nowhere to really look to know what to do until you start doing a lot of research. So when your clients call you, or when prospective clients call you and ask what is going on here, what is the biggest driver behind their question?
The biggest driver it's twofold. The first is a lot of these clients that we receive calls for are federal or state contractors, and they're worried about whether they still have to comply with their affirmative action requirements. And that requires an examination of the executive order, which eliminated some of the requirements for their affirmative action plans and compliance. And the other issue that we've been seeing is companies, publicly traded companies, that have proxy statements, corporate board governance rules, things like that, internal documentation that essentially has to be modified because they had language previously indicating that there was a preference for specific protected groups to serve on their boards. All that language has to be modified, revised, and addressed so that they don't become targets of the Attorney General's office when they commence their enforcement actions, which could happen in the near future. Other questions that we've gotten are about EEO statements. For example, a lot of employers put on their websites, either external or internal, that they're equal opportunity employers. Do those statements have to be modified? Those are the types of questions that we've been getting so far in general.
Does that answer your question, Rebecca?
Yes, definitely. My husband has worked for the federal government for over a decade, and it's a little bit different for him and his coworkers about how everything is happening in the private sector. It's interesting to hear from his perspective what his biggest concerns are and what your client's biggest concerns are as well.
Yeah, because your husband is an employee of the federal government, his concerns are probably a little bit different than the private employers. He's probably concerned at the very least, or at the most, that he's going to be terminated by a DOJ action. And there's a lot of federal employees who have those questions and what their rights are under the federal law, whether they're protected by a collective bargaining agreement, if they're unionized, and if they're not, do they have rights to file appeals for their termination through the Office of Personnel Management? There is a whole federal system that protects federal workers from illegal terminations. Whether or not these terminations will be considered illegal is another matter, or is it the president's prerogative to downsize the executive branch workforce? But that's not something that I personally have legal expertise in, so I couldn't opine on it.
Thank you for that insight, Ken. Does anybody have any other questions? Antonia, do you have a question?
Yes, I do. Thank you. Just curious, is there anything that would prevent an organization from continuing to use pronouns in terms of even their Zoom address or in emails, in terms of who the person may identify with?
So there was another executive order that specifically addressed whether government agencies could or should be using pronouns other than he, she, female, gender related pronouns. And that executive order, I don't believe has been challenged yet. We as a law firm also have considered the implications of that, because we obviously have attorneys throughout the firm, and employees, I should say, that use various different binomial indications of their sex in their signature lines. We're not telling our staff or our attorneys to change that. But if you're a federal contractor, I think the issue is, do you want outward expressions that could draw the attention of the federal government? The probability of a private employer being investigated, or based on somebody using more than just he, she, male, female, gender pronouns, is probably pretty slim. I don't believe it's going to result in many, if any, private employers being investigated just for that alone. But if you're investigated and that is something else that's out there, that could draw additional unwanted attention from the Attorney General's office, because they're the ones that are going to be charged with investigating, reporting on, and potentially bring litigation against companies. They've been instructed by the executive order to identify 9 organs for each agency that has jurisdiction over whatever industry that agency may have jurisdiction over, to identify 9 either businesses, corporate entities, higher educational institutions, not-for-profits of certain sizes that receive federal money for investigation. And so while there's a lot of excitement about, what the government's going to do, the question is how much resources do they actually have to do it, especially with all the downsizing that they're now engaging in. So I don't think that we should be telling our employees necessarily that they need to pick a gender, if your policy was to allow people to identify otherwise. I would not be changing that.
Okay, thank you.
You're welcome.
Thanks, Antonia, for that question. Desiree?
Yeah, I had a question.
Sure.
As companies are proactively shaping these initiatives in a way that aligns with compliance, are there any best practices? I know you've covered a lot of this, but just best practices that we could leave some of the companies with that they should maybe implement or can work toward?
I think best practices for companies under the current environment, what they should be doing is first thing is they should be assessing their policies, determining, when I say policies, DEI, AP, EEO policies, assessing those policies, determining whether they contain any illegal or inappropriate language under these executive orders or under any other existing federal anti-discrimination law under Title VII, ADEA, ADA, etc. And then determining what was the purpose of those policies to begin with. What are the goals and objectives of those? And can these policies be revised in a way to still accomplish those goals and objectives without having illegal or inappropriate language in them? And then following through and identifying what those goals and objectives are. What do we need to still be doing to ensure a diverse workforce, to encourage diversity in the workforce, inclusivity, and then preparing a strategy, a plan that is compliant under this administration's executive orders, and then implementing that plan. And some of the things that I talked about before are all things that companies, businesses, employers can be doing. For example, identifying local recruitment sources, colleges, job fairs, all social media, print, places where we can recruit from to fill and help attract diverse, qualified applicants, performing our impact ratio analysis to make sure that we're not engaging in any discriminatory or reverse discriminatory activities, doing a pay equity analysis to make sure that we're paying people fairly. These are all, I've mentioned it a couple times throughout, but these are all the basics of how to move forward and best practices that companies can engage in. They also, I think, you should be looking at your contracts. If you do have contracts with the federal government, then you definitely have to be more in tune with what these EEOs are requiring. If you have state contracts that have AEP or EEO obligations, again, that may cause a conflict, then you probably need to speak to counsel to determine what is the best approach for moving forward, given the potential for conflict between federal and state law requirements, staying abreast of all the changes that are going on. These are all good things. And obviously making sure that we maintain policies that promote a respectful workplace, because that's really one of the keys to diversity, equity, and inclusion is that we maintain respect, promote respect for all of our workers.
Yeah.
Thank you for that. Christina, we had met with you earlier during this discussion. Did you have any specific questions? If you are still there?
Hi, I'm here. No,
Hi.
I'm not. I am feverishly taking notes on, I think I would ask, and I can probably go and look at the court's order. The one executive order that rescinded that Johnson era, I mean, that federal contractor affirmative action rule has been around forever. Is that, do you know, is that one of the specific parts of the EO that the Maryland judge has put a stop to? It was not.
And
Okay.
I'll tell you the reason why. The reason is there is substantial case law on the federal government's right to require affirmative action plans. And basically the analysis goes like this. If you want to do business with the federal government can impose any legal, essentially legal, obligation upon a contractor to get that contract. And as I'm not sure if you're familiar with the federal acquisition regulations, but they're thousands of pages
The
long.
FAR, the FAR
Yes, the
stuff, yeah.
FARs. And they have numerous requirements. It would take 3 days for us to address all of them. And as a contractor, as an entity that the federal government as a business doing business with other businesses, the courts have said that as a business, the federal government can impose any requirements that are legal it wants. So the opposite is also true. And that's why they haven't said that that part of that executive order has to be enjoined, because The mistake I think that occurred is that Executive Order 11246 was never actually formalized into law. It was only an executive order, which means the president has the authority to create or delete executive orders. They do it all the time. One administration comes in and they, through executive order, impose all these requirements on the executive branch. And then, excuse me, the next president comes in and rescinds those. This was so dramatic because this executive order had been in existence for 60 years.
Yeah.
And no administration had even thought about eliminating it. But times are different.
Okay.
Does that make sense?
Yeah, absolutely. Very helpful. Thank you.
Okay.
Thank you for that question, Christina. We have a couple more minutes left. Does anybody else have any questions? Gina? So her question is for ERGs. I understand that they have to be open. Are there any risk or best practices for a private company to establish recognized ERGs? Basically, what if a group of employees wants to form an official white men's ERG?
And that's a great question, right? Because if you had ERGs that only accepted and only allowed a certain protected class to participate to the exclusion of white males, then one would argue that is a reverse discriminatory practice. So if you're a white male ERG, arguably speaking, under Title VII, then that itself would be discriminatory. I hope that answers the question, but that's essentially how I would analyze it.
Great question, Gina. Thank you. Isn't it general practice that all ERG welcome any ERG?
General practice, that is the best practice, that everybody should be welcome to an ERG,
Yes.
regardless of their protected class or who they are.
Yes, agreed. Thank you all for joining us today. And a huge thank you to Ken for sharing your time, insights, and expertise on this important topic. Before we wrap up, Ken, how can our audience connect with you if they'd like to continue the conversation or network with you, and referral as well?
Great. Thank you, Marie. If anyone in the audience wants to reach out to me, I'm happy to speak to them at any time. My telephone number is 973-994-7510. Or you can reach me by my email address, krosenberg, ROSENBERG, @FOX, Roth, ROTHS, as in Sam, child.com. So that's foxrothschild.com. Or you can reach out to me on LinkedIn like you did.
Yeah. Thank you so much. Are there any other last minute thoughts before we end our discussion today?
Be careful out there.
Thank you. Thank you so much, Ken. Thank you everyone for joining.
My
Until
pleasure.
next time.
Take care.
Bye-bye.
Thank you, Ken.
My pleasure.
Thanks.